on this episode of Trust and Trade.
And as an in-house counsel, when I see certifications that we may be wanting to use to support environmental or sustainability claims, I look at them with a very critical eye. I really want to know a lot of questions. Or if we're looking at competitors who are relying on these, I'm looking at, did somebody pay to play? Is this only a certification they received because they paid for it?
Hello, and welcome to another episode of Trust and Trade, a podcast from the Antitrust Law section of the American Bar Association. On Trust and Trade, we take a closer look at the developments, debates, and emerging issues shaping competition, consumer protection, and privacy law. Each episode is presented by one of the section's specialty committees. Today's episode is produced and co-hosted by the Legislation Committee. I'm your host, Anant Raut. Thanks for joining us. Today's topic? Greenwashing. The term greenwashing refers to making deceptive claims about a product that make it sound more environmentally friendly than it actually is. This could mean focusing on some green feature of it, like that it's made from 10% recycled materials, while eliding a larger negative environmental impact, like increased plastic production. Or it could mean making vague or unsubstantiated claims, like net zero emissions by 2030. Some amount of exaggeration is expected from advertising. You do, after all, want people to buy your product. But there's a line beyond which such claims are no longer mere puffery, they're illegal. So where is that line, and who enforces it? Here to lead that discussion are my co-hosts, Greg Fortsch and Christie Thompson. Greg Fortsch is the Assistant General Counsel for Regulatory Affairs at Nestle Health Science US, where he advises on all state and federal regulatory issues, including advertising and labeling for sustainability and environmental claims. Christie Thompson is a partner at the law firm Kelly Dry, where she advises clients on a panoply of consumer protection legal issues, including advertising, product safety, and promotions. Welcome to the show, Greg and Christie.
Hi there.
Hi, great to be here.
Who are our guests today?
So I'm really excited to have with us Lemuel Srolovic. He is the chief of the Environmental Protection Bureau of the Office of the New York State Attorney General. Is going to share some really terrific insights.
And also, I'm thrilled to invite and welcome Kaelah Smith, who is an Assistant Attorney General in the Environmental Section of the Connecticut Office of the Attorney General.
Well, welcome, everyone. Greg, Christie, can you start us off by explaining what exactly is greenwashing?
Sure. So greenwashing brings to mind the FTC's broad authority over false, misleading, and deceptive sustainability and environmental claims, and its long-awaited update to the Green Guides. But before getting into some of the details of the Green Guides and how they interact with the states, I wanted to provide my brief thoughts on what greenwashing is so we can set the stage for that and ask my panelists their thoughts. Now, from a perspective of an in-house counsel, greenwashing is the term used for broad, non-specific claims, environmental or sustainability claims that have no support or substantiation whatsoever. Claims like eco-friendly or good for the environment, very general, non-specific claims that nobody can point to any substantiation at all. Lem, Kaelah, and Christie, please let me know your thoughts if you agree or anything additional, very briefly, on greenwashing so we can set the stage and then move on to the Green Guides if you have any thoughts.
Sure. Thank you, Greg. First, I do have to give my standard disclaimer. Any views or opinions I may state in our conversation here today are mine alone and do not necessarily reflect the views of the New York Attorney General or her office. All right. With that out of the way, I think your framing, Greg, is excellent. For me, I think of it in kind of three broad categories. One is, say, when an auto manufacturer touts its new generation of diesel automobiles as clean and green, and the pollution control runs during emission tests and is programmed to turn off in real-life driving. That's pretty egregious. More commonly, we see things that an environmental attribute of a product is a small component of the product, perhaps, and really is the focus, the touted attributes of the product with no disclosure about the remaining contents. That's a pretty standard form. And when it tips into unfairness to the consumer, to the market, that's when I think greenwashing is a real problem.
Kaelah, any additional thoughts, or Christie?
Sure, great. Thanks much for inviting me here. One, I also want to give my standard disclosure as well. Any views or opinions that I may say here are mine alone and do not reflect necessarily the office of the Connecticut Attorney General. I think Lem, I think Greg, I think you're both right, sort of framing it like this. I would also say that the disclosure is a really important part as well. That, what actually is being conveyed to the consumer when they're in the grocery store or whatever, looking for products. There's so little time that the consumer takes to look at what's on packaging for a product. And so to the effect that there's coloration or promises that are being made on products that are intriguing to a consumer or that might want to trigger someone who wants to be a good steward of the environment to purchase a product, that's really where sort of the problem is for us. Lots of claims that could be made, for example, if a product is said that it's recyclable or that there's recyclable elements to it, but it's really important to make sure that we really understand and drill down on what actually is recyclable, what actually is sustainable.
Yeah, and I agree with those comments. I would just frame it a little differently coming from, we're often representing companies in this space. And it's kind of when they get a little excited about the good deeds they're doing. They want to tout the environmental benefit that a product has and can sometimes take that too far and make it overly broad or make it about something for which they don't have adequate substantiation. And so I think it's trying to find the right line for companies to be able to promote the good things they're doing, but of course doing it in a way that consumers understand and the consumers aren't being deceived.
Thank you so much. And that was very helpful. It really sets the stage well for our conversation today. And, not to get too technical, but the Green Guides really do address pretty much every one of these issues. But the issue with the FTC's Green Guides is they haven't been updated in over 14 years. And the update was expected a couple years ago near the end of the Biden administration. We really have heard virtually nothing about when they're going to be updated or if they're going to be updated. They, of course, are guidance, not law. And they are just also, more importantly, since we're talking with state attorney generals' offices representatives today, they're just one tool for the states. They are not the whole state's focus. And they're just one way to address greenwashing. And I wanted to ask Kaelah, your opinion, your thoughts on how they are, in particular, these Green Guides, a tool for the states to combat greenwashing.
Sure, absolutely. And so just to that point, we are expecting an update. 2012 was the last year that the Green Guides were in fact updated. I was part of the team, there's a multi-state coalition that submitted comments a couple of years ago to the FTC about the Green Guides. It was a really comprehensive process because it's important to make sure that the document does evolve as the understanding of recycling, recyclability, composting, third-party certifications, the importance of substantiation. So as all of that evolves, it's important for this document, which is obviously a living document, to evolve. And it's a tool. It's one way that states can, and the federal government, of course, obviously, can make sure that we're communicating what's appropriate and what isn't to corporations and to consumers. And the states can go further. It's not the only thing available to the states. So if states' consumer protection laws are a little bit more stringent, a little bit differently situated, this isn't the only tool available to the states.
So, as we've said, the states can rely on other tools other than just the Green Guides, and they don't have to wait for the FTC or the federal government. They've got these other tools, including existing consumer protection laws like UDAP statutes, Unfair and Deceptive Act and Practice statutes, that they can use to address these kinds of issues as they see them. And sometimes they've done that in really unique ways. For example, in sustainability and other things that the federal government isn't currently addressing. They've used public nuisance laws. They've looked to other state laws to address what they perceive as greenwashing. So, Lem, why don't you tell us a little bit about some of the creative or maybe not so creative approaches that the states have taken in this space?
Sure. Thank you, Christie. I think that states do have powerful legal tools outside the Green Guides to address greenwashing. Here in New York, our consumer fraud law recently was amended to add prohibitions on unfair and abusive business practices to the pre-existing prohibition on deceptive practices. And the amendments also strengthen the application of the law in the business-to-business conduct. We also in New York have Section 6312 of our state executive law, and that authorizes the New York Attorney General to investigate and initiate litigation to address repeated illegality or fraud in the conduct of business in New York. Our office uses those pre-existing authorities, and we will use our strengthened consumer protection law going forward to address greenwashing conduct. I think maybe one example of that would be useful to listeners and viewers is in February 24, our office filed a lawsuit against JBS USA Food Company. It's a US-based company that is part of the multinational JBS Group, which is believed to be the largest meat producer in the world. The complaint alleged that JBS violated New York's consumer protection laws when it advertised to consumers that the business enterprise of which it was a part had a commitment to cutting its greenhouse gas emissions to net zero by 2040. The claim itself was not a violation, but the complaint alleged that the claim was not supported by a viable plan or even an analysis to demonstrate that reaching that commitment was even feasible before the advertisements touting that commitment ran in New York and elsewhere. So the complaint alleged that the scope of that project was very large. In 2021, JBS Group's estimated greenhouse gas emissions were larger than the Republic of Ireland's. The problem also was that the company had a business plan to significantly grow its market share, primarily of beef, which is very greenhouse gas intensive in its production relative to other forms of meat. Interestingly, I think before our office filed the lawsuit, we learned that in 2023, the JBS Group had defended a proceeding before the National Advertising Division of the Better Business Bureau, in which a non-governmental organization alleged that the JBS net zero by 2040 claim was potentially misleading to consumers. And a board of the advertising division heard that dispute and agreed with the petitioner, finding that the claim was unsubstantiated. That was appealed to the appellate board, a group in the National Advertising Review Board, and that determination was upheld. So the complaint asserted claims under our consumer protection law. It was in a prior form, pre-amendment, for deceptive acts or practices, false advertising, along with claims under Section 6312 that I mentioned a little bit ago. So after initial motion practice, the parties reached a settlement that includes changes to the company's representations to consumers regarding climate change and sustainability, 3 years of compliance monitoring, and a payment of $1.1 million to a program implemented by a university in New York to advance agricultural practices that reduce greenhouse gas emissions from the ag sector. So I think that's an example of states using state law to address instances of greenwashing.
Was there an instance, I feel like, and I think Kaelah is going to get into this about green hushing in her case that she's going to discuss in a minute, but wanted to ask you, Lem, if there was, because that's a term you hear less often than greenwashing, but was there green hushing in this case that you just described, JBS case, and what does that mean, and where did it come up in that case?
Right. So I think we see often when a greenwashing case, an enforcement case, is brought against a company, a typical response may include, well, we are trying to do the right thing environmentally, and you coming after us for false or misleading claims provides a disincentive for us to talk about environmental progress that we are making and our commitment to that. Well, I think that is incorrect, because we don't penalize and take enforcement action against companies for adopting sustainable and other environmentally beneficial practices. As the Environmental Protection Bureau, we seek to promote that as a matter of policy. But when claims about the environmental attributes are so far ahead of the actual conduct and are specifically designed to give the company an economic advantage with consumers or in the market at the expense of the consumers or their competitors, that's when we take action. And I just don't think that can fairly be characterized as greenwashing at all.
Yeah,
And if
let
I
me just. Oh, can I just have Kaelah? Maybe you follow up on this, and then I've got a follow up question for Lem that's so slightly just closing the loop on something you said earlier.
Well, and I agree with that. And I think you could even take it a step further that there's almost not a threat per se inherent in the idea of greenwashing, but that corporations might say, well, wait a second, state AGs are coming after us. We're trying to put sustainable products out in the marketplace, even if there actually isn't, substantiation of any of the claims they're making. Well, then we just will back off. We won't do that. We won't do any further R&D about sustainable products or marketing materials. And so it's the idea that Lem's exactly right. We want as a matter of policy, companies and corporations to do good, to put products that are environmentally sustainable, that give consumers good choices out into the marketplace. We absolutely encourage that. But there is a line, obviously. And if there's claims being made in the advertising or marketing of a product that are not actually viable, aren't actually substantiated, that's when the state agencies have to get involved.
Yeah, I think those are good points. It comes to this fundamental concept of consumer protection, right? You have to be able to back up what you say and support it. And that's nothing new in the world that companies are living in or that regulators are living in. And you've got these multiple tools to do it. Lem, just one follow up on some of the issues specific to the JBS case. I get a lot of questions about, we've got this great plan. This is our goal. This is what we're doing. Do you see lines in terms of like what JBS really crossed that created concerns for the AG's office? Are there words that companies should use, companies should avoid when talking about their plans and their goals?
I think that's a great question, Christie. Thank you for that. I think the problem we saw in the JBS conduct was not the commitment to net zero by 2040. That's a laudable commitment, right? But to make the claim in the absence of even an inventory of how far the company would have to go to get there, a plan to get there, and a realization or a reflection that, look, this is a commitment. We're trying. It's aspirational. We may not make it, but we're going to give it our best try. That would be a very different kind of conduct from an enforcement perspective. But if you hail a ride share and they say, we will take you to the destination you want to go, we know where it is, we have no idea how to get there, we don't know how far it is, we don't know if we have enough fuel to get you there, well, I don't think you're going to be too happy with that driver. So it's, I think, analogous to that. We really promote and seek to promote sustainable conduct, sustainable claims, but they have to be backed up and they have to be realistic and they have to be fair to consumers.
Absolutely. I think that's always my advice to clients in the company, within the company. The more specific you are, the better. The more general you are, the worse. And if you're specific, there has to be very detailed substantiation, because I think we do know very well that there is a strong and a very high level of consumer interest in these kinds of claims. And because of that, consumers buy products based on these claims. So we don't want them to be absolutely lacking in any substantiation whatsoever and drawing people in based on claims that are aspirational, which are fine if there's substantiation for them. If not, they're just not useful claims. And I wanted to maybe take this opportunity to now turn to Kaelah to talk about a case in Connecticut that has some similar issues, some parallels, greenwashing as well, to talk about the Reynolds case. Kaelah.
Yeah, sure. So back in 2022, which is crazy that it was 4 years ago, we brought a case against Reynolds Consumer Products and for a product known as their hefty recycling bags. The complaint alleges that this was a product that was put onto the marketplace circa 2017. And the product is as advertised, as we allege in the complaint. It's a product that it directs consumers to take their otherwise good recyclables like milk jugs and cardboard and aluminum seltzer cans, put them into this particular recycling bag that has, as we allege in the complaint, that has labeling on the box of bags that says perfect for all of your recycling needs. It has a blue pictogram of a blue recycling truck with the recyclable symbol on it. And so the packaging and then all of the associated advertising material, it directs consumers, like I said, to do this, to take their good recyclables, put them into this bag, tie it up, put it into their, their blue bin for curbside collection in Connecticut. The problem is in Connecticut, that plastic bag, because it's a plastic bag, and all of the otherwise good recyclables are not recycled at any Connecticut materials recovery facility. So it's a MRF, an MRF. Instead, the bag, as we allege in the complaint, the bag and all the otherwise good recyclables are either landfilled or incinerated. And so, you have consumers that are in the grocery store, they're in the hardware store, and they're walking around, looking for products that they want to be good environmental stewards. They want to be conscientious about what they're doing. This is a product that I understand why you purchase. You think that this is going to do something that it's a recycling bag. You assume, we allege anyway, that the consumer is going to think to themselves, oh, okay, well, this is perfect. This is perfect for all my recycling needs, as the packaging alleges. But in Connecticut, that's not true at all. And so we've litigated this case for the past 4 years. We actually just concluded trial. We don't have a decision yet. We're in briefing stages right now, post-trial briefing stages. But it was a really interesting experience for us. So I'm in the environment section. We have all sorts of environmental statutes. We do a ton of, solid waste enforcement and hazardous materials enforcement, but we're trying to get creative, as we were talking about earlier, and use all of the tools available to us. So in Connecticut, our unfair and deceptive trade practices statute is CUTPA, the Connecticut Unfair Trade Practices Act. And it's a super broad statute. It's remedial in nature. It really looks to make sure that we are protecting our consumers. Obviously, an individual certainly could bring a lawsuit under CUTPA in Connecticut, but we're the AG's office, and we speak and we work on behalf of the entire state and all of our constituents. So we're trying to get creative as much as possible to crack down on instances where there are products that are being marketed in the state and then nationally, obviously, that we allege are unfair and deceptive to consumers.
Well, thank you so much. That was really great and interesting. And I wanted to just briefly move on to the New York Pepsi case. We wanted to have a little segment about things to watch as part of our podcast. And one of the cases we were thinking about was the Pepsi case in New York. So Lem, please let us know in the context of, using those UDAP laws that we talked about, the unfair and deceptive trade practices laws and public nuisance laws. Take it away with the Pepsi case, if you wouldn't mind, please.
Thank you, Greg. So the Pepsi case is a lawsuit our office filed against PepsiCo and Frito-Lay in November of 23 concerning plastic pollution in the Buffalo River, which is an important recreational and natural resource that flows into the Niagara River a few miles upstream of Niagara Falls in downtown Buffalo, New York. So for decades, volunteers have performed annual waste cleanups along the Buffalo River and along waterways really across the country. They then tabulate their data and make it available publicly. So we reviewed that data and we saw an increase in the abundance of plastic packaging as a component of the waste picked up along the Buffalo River and other waterways. So in 2022, to better understand who was behind this plastic packaging waste, our office surveyed all types of waste collected at 13 sites along the Buffalo River and its tributaries. That survey revealed that nearly 75% of the waste items were plastic waste. And then we tallied the waste by any identifiable branding. And that tally revealed that PepsiCo's plastic packaging was 3 times more abundant than the next brand identified contributor, which, as our complaint alleges, was McDonald's. So that case has public nuisance and other tort elements for contribution to the plastic pollution problem in the Buffalo River, including microplastics, which the plastic breaks down into in the environment. But the case also has a greenwashing element concerning claims made by Pepsi about a recycling-based circular economy for plastic packaging to help ensure, these were the company's words, that materials used in packaging are recycled and reused rather than becoming waste. That sounds good. That would be good. But the complaint alleges that Frito-Lay snack wrappers are not recyclable at all, and Pepsi's plastic beverage bottles can only be recycled a limited number of times before the plastic resin can no longer be formulated into new bottles. Beyond claims about recyclability of the plastic packaging, the complaint also alleges that Pepsi shifted the goalpost on reducing its use of virgin plastic in a manner that suggests its use of virgin plastics is going down when in fact it's going up. In October of 2020, the trial court hearing the case dismissed the complaint for failure to state any claim. We appealed. The appeal now is being briefed. It's scheduled to be argued this September, and we expect a decision later this year or early next. So I think the Pepsi case is an interesting case in this space to watch because it really is trying to establish producer responsibility, not for all of the plastic pollution problem in New York, but for contributing to the problem that is unfortunately growing in size.
Yeah, that's great. And those are really good examples of where your specific states have focused and some kind of claims and company actions that have gotten on your radar screen. We've also seen collaboration among states, particularly increased since the FTC lost some of their ability to pursue monetary relief after the Supreme Court's AMG decision. And we'd love to hear maybe from you, Kaelah, about multi-state efforts in this particular space when it comes to environmental benefit claims and what you're seeing there.
Yeah, definitely. It's also an interesting question too, because when you think about it, the states are so differently situated. There's states that are coastal states that are maybe have more of an interest about microplastics in the waters of the oceans. There's states that don't touch any coasts that have different needs. So it's definitely really interesting working with collaborators and folks in other AG offices around the country to sort of understand what's necessary and what we're focused on. But in the same breath, it's really important for us to develop and to work with folks across the country to think necessarily about how we can utilize the tools available to us to ensure that both the environment is protected, but also that consumers that want to do this work as well are best supported.
And a good example is when the effort you led that we kind of started with in the work to prepare comments in response to the FTC's request regarding the green guides, where the states collaborated, even though you may have different interests or different enforcement opportunities or priorities. This is an area where you've kind of created a group and provided comments on the green guides.
Yeah. And to that point, Christie, what was really interesting, I was thinking about this in preparation for the podcast today, because we submitted the comments, I believe it was 2 years ago. And so one of the things that we really pushed on and that was really important to us was sort of redefining and essentially broadening the definition of recycling and recyclability. Because I think the 2012 version of the Green Guides, it essentially says that you can't make a claim that something is recyclable if it can't be recycled in an established recycling facility. And that's fair enough. And that, that makes sense. Maybe that made sense in 2012. The thing that we really focused on is the question is not whether or not there's a facility that could recycle something, but it's whether or not a person has access to that facility. So for example, if there's an established recycling facility that's 800 miles from your house and a product is sold that is ostensibly recyclable, Well, great, but you have no actual access to recycling it. And that's the problem. So that was a really interesting and a really collaborative, multiple months of efforts, obviously, to put together these comments. But we did, and we worked really hard on them, and we were super comprehensive about it, because just thinking about, like, that's important to make sure that is centered, for example, in a discussion of recycling. There's lots of other stuff that we talked about in the comments, but that was a really intriguing and really important thing to sort of to highlight, to make sure that consumers actually, when hopefully the FTC does adopt some or all, or does make the revisions that we assume they're working on, that they really make sure that that this document is a living document and it's evolved as much as it really should to face the challenges that exist today. They were different, obviously, than what faced the country and the federal government in 2012.
Yeah, and I think the comments do provide great insights on where the states are focused in the absence of an update to the green guides. We've directed clients to them to say, hey, look, even though the green guides say this, states aren't bound by that. So look to the comments to see, particularly on recyclability, where we get a lot of questions, to see the priorities at the state level. So that's really helpful. Thank you.
And for our listeners who are interested in a deeper dive into something that Christie mentioned about the change in the FTC's remedy authority, I encourage you all to listen to one of our prior episodes, The Rise, Fall, and Fallout of the FTC's 13B Monetary Remedies Authority, which goes into great detail about what happened before and after the FTC versus AMG case. I was also interested in hearing how our panelists today were talking about how the states have been going their own way when the federal government hasn't been as active necessarily. That's been a recurring theme in some of our antitrust episodes of the show. And so it's just been interesting to hear the same theme coming up in the consumer protection side of the house. Greg and Christie, we just got a new fridge for our garage. And on the side of that fridge is like this Energy Star logo. And listening to this fascinating discussion made me wonder, are these third-party certifications, are those an effective way for companies to shield themselves from potential greenwashing claims?
Yes, so they can be, typical lawyer answer, but you really need to look at them very critically and make sure, and with caution. The green guides obviously talk about certifications, but they obviously point out that they need to be looked at critically as well, because certifications should be independent. They should be robust. They should not be pay to play. And as an in-house counsel, when I see certifications that we may be wanting to use to support environmental or sustainability claims, I look at them with a very critical eye. I really want to know a lot of questions. Or if we're looking at competitors who are relying on these, I'm looking at, did somebody pay to play? Is this only a certification they received because they paid for it? Or is it independent? What are the criteria? Is it robust? So those are some of the thoughts from an in-house counsel perspective, and also a former FTC lawyer. When I look at certifications, I say, yes, but I want to look at them. I'm interested in them, but I'm going to look at them critically.
I would just add that once you've gotten over the bud and you're okay with the certification, exercise caution in wholeheartedly adopting the logo or the claims that come with the certification. We have had questions from regulators in the past where we had used a certification that, as part of their trademarked logo, included claims that the regulator had concerns with and were holding the company responsible for those claims. So as Greg said, it's a definitely proceed with caution when relying on those kinds of claims, because they can give consumers a sense of authenticity and credibility that may not always be accurate.
We have covered a lot of ground on this episode, and we always like to end with a few key takeaways for practitioners. So Greg, let me start with you.
Sure. A couple for me. One is one of the central themes of today's presentations, and thank you again to Lem and Kaelah for being our guests today, and to Christie for being my co-host and helping prepare for this. One of the two that I have is that obviously the central theme is states have creative ways to address greenwashing. They're not sitting around waiting for the green guides to be updated. There are elements from the green guides that they can use, but they have lots of laws that they can use beyond relying on the guidance that is in the green guides. They also have interesting methods for going about their ways. We learned about the Pepsi survey that was done for the waste in the Buffalo River. So keep an eye on the AG's offices, not New York and Connecticut in particular, but lots of the states. Another takeaway that I would have is that, and I don't want to borrow too much, but Kaelah made this point excellently. States are not in the business of discouraging environmental claims. They, just like the FTC and frankly, just like in-house counsel and counsel to companies, we want our clients, we want companies to have substantiation to make claims. So there are very few claims that are out of the realm of possibility, but if they don't have substantiation, they are not worth making. And states don't want to see them, in-house counsel don't want to see them, and outside counsel representing companies don't want to see them either.
And I would just follow up on that a bit. And of the wide range of environmental benefit claims that companies can make, I think that we're getting a lot of questions about recyclability, and we've seen a lot of regulatory activity in that space, a lot of class action activity in that space. And it's one that has been evolving a little bit in terms of what the expectations are. We heard Kaelah talk about the proposal that the state AGs made in terms of rethinking about recyclability and shifting that focus to more on what can consumers actually access with respect to recyclability, not just is the product capable of being recyclable. So I would keep a particularly close eye on those kinds of claims. And again, like there are plenty of other claims that companies can make with a maybe more established standard and expectation surrounding them.
Christie, that makes so much sense to me. So in terms of takeaways for myself, first of all, thank you so much for the invitation and this really fascinating conversation. I've really enjoyed this whole process. But just to that point, states don't want to discourage. We welcome companies and corporations that are doing their best and are trying really hard to put out products that are good for the environment, that lead to a sustainable future for our state and for the world at large. But there is a line, and we have a lot of tools in our toolkit to address claims that are made, marketing that's put out into the stream of commerce that is deceptive. And we're certainly not afraid to exercise the powers that are delegated to us by the legislature to do that. But again, all we want is just to protect consumers and to make sure that consumers are not being deceived by products that seem like they might be good for the environment, but in fact aren't. This has been a great experience. I'm glad that I got to participate in this process.
So first, thank you so much for inviting me to this conversation. I think for me, a key takeaway is that greenwashing is an active arena for state attorney general enforcement. And despite significant disagreements between states on environmental policy, I think there is strong agreement on the need for state attorney generals to protect consumers and other market participants from overreach in advertising, including environmental advertising.
Well, thank you, Greg, Christie, Kaelah, Lem, for helping us all understand the legal consequences of deceptive environmental claims. To our listeners, be sure to watch our video shorts on YouTube and subscribe on your podcast platform of choice. And we'll see you next time. Trust and Trade.